Hi, I'm Michelle. Welcome back to Finally Revealed. In this episode, I want to talk about guardians and conservators. The words are often used together, but they don't always have to go together. They don't always have to coexist, and they don't have to be the same entity or the person. Guardians and conservators are appointed through a trust that's independent, or a trust that's set up through a will, or a court proceeding. A court proceeding because the person is elderly and cannot handle their own care, or they're young and they've lost their parents, or they otherwise don't have anyone looking out for them, or it's set up through a proceeding, is set up through a will. And a guardian and a conservator can be a person or an institution. When it's a person, that person who's the guardian is responsible for the ward, who is the either disabled person, elderly person, or the juvenile, the young person, and they're responsible for their everyday needs. They're responsible for their housing, their medical care, their clothing, their food, their education, and transportation, and their everyday functions of life, in providing it, overseeing it, keeping them safe, and making decisions. When there is a conservator, that is again a person or an entity. It could be a bank, a trust company, or some such. That part means they're in charge of the money, funding the education, funding the health care, funding the housing, funding the food, giving them an allowance, or however it is set up. When it is set up through a court, such as going to apply for guardianship for someone, the court is going to decide, according to the rules in that jurisdiction, who is going to serve as the guardian and conservator, if it's going to be a part of the court system, or if it's going to be a distant relative, or someone else who is close to the ward and who has the ability to perform the functions. Conversely, when there is a conservatorship appointed or sought, either through the court system or some other procedural avenue it's also going to be through the court. When a conservatorship is set up through the court system, again, the court is going to decide who is going to be in charge of the funds. And the funds are a trust fund that has been set up, and maybe the trustee is no longer available to serve, or there were not suitable substitutes, and now it's kind of gone to the court to decide. Or it's a trust company that the court is going to appoint, or it's a court personnel, or some such. They're going to make that decision. Where you can have control over who is the guardian or conservator is in your own documents. If you have a family trust, you can set up the guardian and conservator there. If you have small children and you set up a trust to be effected when you die, if your children are not old enough, you designate the guardian and the conservator in there. If you have an inter vivos trust and you're providing for division of family property, you probably don't have a guardian in that case, but you're going to have a trustee, which is like the conservator. So conservators are over the money, guardian is over the person. They don't have to be the same entity or the same person, and it's something for you to think about as you're doing your estate planning and how you're divvying up your assets or making these types of decisions, because you might not want the same person who is over the child to have the money, or you might want them to. Same thing for yourself. If you're setting up your trust and you want your trustee, if you lose capacity or in some other fashion to have your finances taken over by someone else, you can have that be a trust company, or you can have it be a person. So I hope that clears it up and it makes sense. If you have any questions, leave them for me in the comments. I'll be happy to answer. If you're interested in our other videos, please subscribe. Share this with someone who might need the information, and I'll see you next time. Thanks.